And it's day 2 of the 2020 election petition. There is a lot that happened today at the Supreme Court that we're going to get into. Mainly has to do with the election petition and John Mahama's dismissed motion. We're going to look at the implications of this because as far as the NDC is concerned, it has significant implications for their case. We're going to dissect it for you here on PM Express with the two sides, but also a private legal practitioner in the middle of things. Now, we know that the Supreme Court today dismissed the motion by the NDC presidential candidate John Mahama. He was seeking permission of the court to get the Electoral Commissioner, the chairperson, to answer some 12 questions, right? 12 key questions that he wanted the Electoral Commission chairperson to answer. But these questions relate to some key matters. It has to do from the what we know so far in terms of the key questions. This is one of the central questions that the NDC team, of course, the John Mahama, through his lawyers, were seeking permission of the court to ask. There are 12 of them. I want to highlight a few of the key ones for you. This one, it says, is the December 7 presidential elections the first time of using the regional coalition centers? This is sort of a summary of the key question there. In essence, asking the Electoral Commission if the December 7 was the first time we're using regional coalition centers. I mean, many will say, but this is pretty obvious. We all know it was the first time. So what's the point of this particular question? We'll get to the heart of that when we speak to the John Mahama's lawyer, who will join us shortly. Why ask a question about what the answer is pretty obvious? Well, is it part of a strategy? Another question that they were asking today, they were seeking to ask today of the chairperson, how were the results transmitted from the constituency coalition centers to the regional coalition centers? Again, is it that they don't know, or they just want clarity on this matter for the avoidance of doubt? Again, they ask, how were the results transmitted from the regional coalition centers to the headquarters of the EC? So you're looking at the transmission process, one from the constituencies, one as it has been declared, to the regional, and then from the regional to the headquarters. And they wanted clarity on how the transmission was done. But if you go to the next question, you get a sense of why these two questions are important, right? They asked this next question, which is key. Did the National Communications Authority facilitate in any way the transmission of results to the headquarters of the EC? You read through the questions that they were asking, and when you land on this last question flowing from the previous two, you get a sense that maybe the John Mahama and his team may know something that they want to clarify, because this, as Chachu Chikata stated today in court, only demands a binary answer. Is it yes or is it a no? But there is something more at play here that I guess may become clearer as the case grows at the Supreme Court. Another question, when did the EC chairperson first realize there were errors? Remember that the EC chairperson had admitted herself that there were errors. And so today the question was raised, but you already have answers to this already because she's admitted. But they were asking the question, when? And then they asked the next question, how? How did he come to realize, how did she come to realize that there were in fact errors, right? I mean, they want to know too. So the Supreme Court, having heard the motion, having entertained it, had the arguments, gave a ruling, dismissed it in essence. But this is what the court said. It made reference to CI 9069, C4 of the Supreme Court Amendments Rule CI 99, which directs the expeditious disposal of the petition and sets timelines for court to dispose of the petition. Remember, this is governed by a strict timeline. The Supreme Court's view is this doesn't allow room for what the John Mahama was trying to do today in court through his lawyers. Again, this says that the rule implies that even amendments ought not to be granted early, as well as rejoinder of parties, right? The joinder of parties instead. The court then concluded that it is strictly bound by CI 99 and will not apply Order 22 of CI 47, 2004. In essence, the court simply says the strict rules does not allow them to even entertain this, but they did entertain it. And so, in essence, they can't, if they are entertaining all these motions, it will violate the strict rules that is governing the process, right? And therefore refuse to grant the application. So this has been decided. Tomorrow the case continues, but I wonder of what implications is this to the case itself. Remember that the MPP argument today, well, Nana Addo's argument today through his lawyers, is that this is a delay tactic. But if so, why will the petitioners pursue any processes that we delay the process? Because they probably will want this dealt with expeditiously. We'll deal with that right now. I want to bring in right now a member of John Mahama's legal team. Of course, Dr. Dominic Ayine, who joins us right now. Doc, thank you very much for your time here on PMX. Also joining me is Kojo Nkrumah.
Evans, for having me.
Yes. Also joining us is Kojo Nkrumah, who is also speaks for the Nana Addo team, of course, in court. We'll also speak to a private legal practitioner, Martin Kpebu, on these very important matters. I guess I want to start with you, Dr. Ayine. Some have asserted that your process today was actually meant to help narrow down the issues and may save more time. But as the ruling indicated, there was no space in the procedure set out for this particular petition to entertain something like that, and therefore was thrown out. The MPP accuses you of this as part of a ploy to delay the process. Is that what it is? Was this part of a legal strategy to make this drawn out a bit longer than it should?
Yeah, Evans, that is really paradoxical, because I am sure both my colleague, the Honorable Kojo Nkrumah, and I mean, of course, my friend Martin Kpebu, my learned friend Martin Kpebu, would agree with me that the process that was used today, that is the application for interrogatories, is designed, to expedite rather than delay trials. The process of interrogatories is part of a broader process of discovery, of documents, of information, and so on. So it was designed to elicit, as much information as possible from the first respondent with a view to narrowing down the issues that will be sent to trial by the court. And remember that this was preliminary to the, case management conference that the parties were supposed to have with the court. So our intention, actually, in bringing the application for interrogatories was to elicit answers that will narrow down the issues for trial for the court. It was never our intention, and we did this in good faith, and we believed in the mechanisms, established by law and practice, under the High Court Civil Procedure Rules, which supplemented up to this point, and surprisingly, the ruling of today basically upends any attempt to fill in the gaps in the Supreme Court rules, that is CI 16 as amended by CI 99, by resort to CI 47. And I would want to explain for the benefit of the non-lawyers who are watching us. Basically, what happened is that the Rules of Court Committee enacted CI 16 to govern procedures in the Supreme Court. But because the Supreme Court's jurisdiction is mostly appellate, and then also, of course, it has original jurisdiction in constitutional matters, there are usually no issues of trial and evidence and so on coming up, before the court. So in the wisdom of the Rules of Court Committee, they provided that in situations where issues of that nature crop up in a Supreme Court adjudication, then the rules provided for in the High Court Civil Procedure Rules, that is CI 47, will be called in aid. And that is how come that learned counsel for the petitioner, Mr. Chikata, referred to the decision of the court itself in the 2012 petition, where a similar application, ironically for interrogatories, was, filed. Okay, and it was granted, and in granting the application, Justice Badegbe, now retired Justice of the Supreme Court and a very revered judge when it comes to matters of civil procedure, made the statement that where CI 16 does not, provide for a procedure, resort can be had to the provisions of CI 47, and that is what we did. Okay. Now, relating to the, in respect of the issue of relevance, it's very interesting that the Supreme Court itself, basically adopted the argument being put forward by my learned friend, Mr. Justin Amenuvo, that to the effect that the issues that we had brought, the questions that we had raised were not relevant. But in doing so, he did point to the fact that those issues have been, dealt with in the answer and in the petition. Now, Evans, if the lawyers on this program will agree that the basic tenet, in formulating issues questions for interrogatories, okay, is to elicit, more germane information relating to relating to the petition or the pleadings. All right. And so what we did was basically to go back into their answer or the respective answers of the petitioners and to formulate questions that were designed to elicit that information so that the court, will be guided and the parties will be guided by that information in formulating the issues for trial. So there was no intention on our part to delay the trial. In fact, we would want this trial to, be conducted as expeditiously as possible. And that is how come that, we brought this application.
So the court, of course, we know dismissed it. But if you go to, the argument that your colleague, Dr. Ayine, had just posited right now, it was simply to narrow down the issues, which is really what the court would have done. It was asking you to do in the pre-trial, right? So wasn't this in the interest of all sides, really, to get to know some of the key details that this case, of course, will revolve around? Do you have Mr. Ponkroma with me?
Yes, I'm on the line. Evans, okay. Can you hear me?
I can hear you, yes.
Yes. So good evening to my colleagues, Dr. Ayine here in Parliament and elsewhere, Martin and Dr. Ayine as well, at the bar. I think that we need to start off by settling some matters. There's a history that is beginning to gradually line up at the Supreme Court. Maybe early days yet, but we are beginning to notice a pattern. And that's why we believe that contrary to what our colleagues on the other side may be merely mouthing, what they are doing in effect or de facto is seeking to introduce interlocutories that will delay us from getting to the substantive matter. And I'll explain. The history, for example, includes that ordinarily, when the petitioner sets out his petition and the respondents put out their answers, ordinarily, the next step will be for the Supreme Court to empanel, and when the hearing starts, to start with case management, and then we move on. The first stumbling block that was put in the way of that was an application for leave to amend the petition that was filed by the petitioner himself. He had all the liberties, all the times at his disposal. He made mistakes in it. mistakes that he claims were not necessarily material, yet he wanted to seek the leave of the court to get more time to go and correct it. And one of the grounds on which our lawyers opposed that was that we begin to sense an attempt to delay the process. Today, the court had advertised that we're coming for case management. Our colleagues again did two things that we believe evince what they want to do. The first is that despite all the time they had at their disposal at all material times, at the times that we filed our answer and it was served on them, on Thursday when we went to court, on Friday, even on Saturday that the court registry is still open, they did not file an application to serve interrogatories on the EC. They elected that at 2:30 p.m. the day before we go for case management, then they sneaked in an application for leave to file interrogatories. And litigation and advocacy is not just what is on paper, it's also about the body language, the drama, and everything that goes on. You would notice in court the extent to which Mr. Chachuchi Kata, counsel for Mr. John Mahama, went, even as far as, because the application before the court was an application for leave. But he sought to use that as an opportunity to now deal with the specific questions on the annexure. And when it came to the critical question of the conditions under which you qualify to be granted leave to to be granted leave to serve interrogatories on either party, he sought to suggest that there's a thinking that CI 47 might not apply in this case. And you notice that the court did not even, in its ruling, say that CI 47 does not apply. The court didn't say that. This afternoon, I don't
think, with all due respect, Mr. Kojo Ponkruma, I don't think that was the trust of Ms. Chikata's argument. On the contrary, he amply referred to CI 47 and particularly Order 22 and cited all the provisions that
Dr. Aine, if you let me.
Yes. Okay.
If you let me, Doc, you are complaining that the court didn't give you liberties. On a lighter note, you should give me liberties to
okay.
Make my submission.
I grant you your liberty to make your submission. Thank you very much.
So he started off by suggesting that there's a thinking that CI 47 may not apply in instances like this, and then proceeded to explain why he thinks it applies. Now, the substance of the questions that they had annexed to the application, about 2 or 3 things were happening. You see, when you say you want to serve interrogatories, and my learned senior colleague was very right, it's part of a broader process of discovery. And the broader theoretical objective is to narrow down the issues. Mm-hmm. But the courts have been clear over the years that you don't use interrogatories as a platform for a fishing expedition. And I'll come to that. If you come under interrogatories and what you're actually doing is a fishing expedition, the courts, despite your announcement that it is a good thing you want to do to shorten the process of the trial, they will throw you out because they can tell in substance what you are doing different from what you are saying. That's one. Number 2, if you come for interrogatories, the questions you are raising must be of items that are in question, i.e., you have put something in your pleadings and I have answered, and there's a matter in question, and you are looking for, and I use this expression loosely at this stage, some further and better particulars, and I use it as a loose term in this stage, so that you can narrow down the issue, so that when it gets to case management, the issues that will be set for trial, we all now understand that, okay, you know what, this whole petition, there are 3 or 4 issues. Theoretically, that's what it means. But when you come and you raise matters that are not in question, again, the court will throw you out, despite the fact that you have announced that you are here because you want to expedite the trial. Now, today, 2 things happened. In fact, 3 things happened. There were issues that were clearly of a fishing expedition. And that is betrayed by something Mr. Chachuchi Kata did after this application had been heard. I'll deal with that one later. Apart from the issues that were of the nature of the fishing expedition, there were questions they were asking that were not matters in question. They hadn't pleaded it. We hadn't responded or answered to those issues. There were matters that even judicial notice can be taken off, yet they were coming for leave to ask those questions. And then there was the question of relevance, or what the court in the certified ruling says, relevancy. On all of these three grounds, we were of the view that that application is a disguised process to delay what we should be doing today, which is case management.
To what end?
The end,
to what
the court
end?
said,
to what end?
Because, and we believe that for all intents and purposes, what Mr. Mahama and his legal team have been forced to do is that despite the false claims that they made to their supporters that they had, that Mr. Mahama had won this election, Mr. Mahama's claim at all material times before this petition in public at press conferences was that he had won this presidential election. Despite that, now when they appear in court, they abandon that claim and spend a lot of time complaining about errors that were made in the verbal declaration and a press statement that was made. Now they have to, in their pleadings, as they have pleaded, they have to advance evidence to either question the validity of the election or the results. And knowing they cannot do that successfully, they are resorting to these, what we believe are theatrics, so that they will probably get some more airtime on TV, trying to, purport to be litigating a matter. So specifically, here's what happened. The court said, or the court agreed, we believe the court agreed with our view that if you ask a question that at what point did we start doing regional collations of presidential results? My God, this is a matter that is not in question. It is not in question. The law in front of you, CI 127, which was passed by the Parliament of Ghana and assented to, has a date to it, and clearly shows anybody on the face when we started doing regional collations. Is it an issue in question for which reason you should be granted leave to file interrogatories? If you start introducing new, what we believe are pleadings through the back door, bringing the NCA and now a new, may I say, purported charge at the NCA through the back door, it's never been an issue that is, or a matter that is in question. And if you want to raise some other issues, you have to demonstrate before the court, in all the 30 or 45 minutes that Mr. Chikata got, that these matters are relevant, not that they are serious issues. And here, relevant doesn't mean serious issues. They are relevant to your pleadings and to the substance of your case. And the court was of the view that they were not. Now, here's my final point.
Yeah, very quickly.
When the court was done with that and asked Mr. Chikata that the original reason for which we are here is for case management. The expectation is that today, when you are coming to court, you come with case management, may I say briefs or notes on case management. So you have your draft issues as at least a basic. 2:30 p.m. yesterday, you tried to suspend the process. This morning, you actually filed a request for answers this morning. I'm told this morning they filed a request for answers. Now, go ahead and propose your issues. Mr. Chikata was now asking for a date for Thursday, something that we knew we were coming to court today.
But to be fair to him, he wanted to see the text of the ruling before...
It didn't change. The certified true copy of the ruling does not, and for a very short ruling like this, does not differ in law or in substance from what was read by court. But that's not even my point. Here's the last thing. I don't know if you know that since we left court, they have filed another interlocutory process.
Yes,
I don't know if you're aware of that.
Yes, I know that.
And we believe that all of this is part of the attempt to delay the substantive matter because they know that the substantive matter that they have pled or they have pleaded before the courts is difficult for them to litigate.
Okay, so I'll come to you, Dr. Ayine, and there's a lot you need to respond to. But let me bring in Martin Kpebu, who's also with us. Mr. Kpebu, was the interrogatories necessary, needed?
Evans, this particular question, you're putting me on the spot, right?
I mean, for the honorary man, that is the primary question. Mm-hmm. It's a question of how much of a difference would it have made to the case itself in the interest of justice, for example?
You see, let's do this. The court was seized with the matter. And, we are all guided by the decisions of the court. So once the court doesn't deem it necessary, it's difficult for me to depart unless there are very clear reasons. But I must state that personally, okay, yeah, what you're most interested in, the question about the NCA, whether the NCA helped, it appeared very interesting. I would have loved to hear the answer to it. You know, maybe it's conspiracy theories, but as soon as the NCA was brought in, I was like, oh, is that the dimension? You say, so
and an answer to the affirmative on that one would have had serious implications, because I know the NDC probably would have gone to say, oh, but the man at NCA who heads it was a man who was heading the MPP's collation center. And so if he was, his agency was involved, I mean, so you get to see why I guess you're saying you are interested in hearing the answer. We were all interested in hearing the answer.
Yes, so that's the particular one. I mean, I was like, wow, but it's good. So you see that it's good for our democracy. Look, even though the application was shut down, Evans, don't forget, look, this case is not purely a legal case. It's also very political. What I see at play here, apart from the legal aspect, is that the NDC is seriously selling a case of a stolen verdict. Seriously selling. So you see, what is happening is that each day, as we get up and talk about this case, you know, what is at the bottom of it? That the EC made some errors. And then to the layman, that somebody benefited. So you see that psychologically, we are being tuned, okay, to say that, oh, there was a stolen verdict. The extent to which it will succeed, I cannot measure, because of course I can't do a scientific poll.
Do I hear you say, I guess, in confirmation of the MPP's suspicion, that there is more at play in these motions that the NDC, well, John Mahama keeps filing, than just a matter of advancing the interest of justice. And there's something more at play than that. There could be politics, there could be winning the argument in a court of public opinion, and not necessarily in a court of law. Do I hear you say that that is also key in the approach you're adopting?
Oh, definitely. It goes without saying. And sometimes the court of public opinion may even matter more than the courtroom. Look, and let's not kid ourselves. In 2012, when the MPP mounted this petition, I mean, that was also at play, very much so. So by the time we're done, we knew that, oh, if not for anything at all, Nana Akufo-Addo had been cheated out of something, even if it didn't amount to a total win. And you know, till date, you can read the judgment, and you see today the Chief Justice is presiding. If you read his opinion, you see for him canceling a lot of the votes, okay, that there was overvoting, okay. You read the opinion of Bafuboni, canceling a lot of the votes and asking for reruns and all that, you say. So there is a lot of a case of stolen verdict being played out in the public opinion. It doesn't matter what the courts say. You say, yeah, so that is
do you buy the MPP's argument that this is part of a ploy to delay the process so you get more capital out of the stolen verdict, for example, argument?
For that one, to be honest, it's impossible for me to answer. It will be purely speculative. Let's just say, perhaps it's a collateral benefit whilst trying to use the law. You know, the interrogatories, request for the documents, inspection of documents, those are tools that are available to them. So when these are deployed, I would not easily buy into the argument that this is a delay tactic. Don't forget, we have 42 days to wrap up this. Even though it's beginning to look like the court will need more time, Evans, I don't think we'll end up doing 84, okay? So either the court will finish at all costs within the 42, or at least maybe a week or two after. So the court is very minded about the timetable. And let's quickly make this point before we get there. Please, if the court goes beyond 42 days, it is no crime. In our laws, the Supreme Court has already held that if you're given time to deliver a judgment and that time passes, it doesn't render the judgment invalid. No, it's just an administrative matter that can be dealt with, but the judgment stays as a judgment of the court. So you see that today is day 20th because the president was served on 31st of December, right? And today is 19th January. So if you add 31st to today 20th, we've done 20 days. And so we have 22 more to go. Originally, under the CI 99, we were supposed to have started the trial on the 15th day and end on the 21st day. That's 7 days. Today is the 20th day. The trial hasn't started. So invariably, we are going to take it into part of the time allotted for the justices to retire for their verdict. So you see, tomorrow will be the 21st day. So it means that if we're going strictly by the timetable, tomorrow we should have concluded the actual trial. So I'm talking about the last time Dr. Baumia mounted the box and got a lot of applause for it. You and I were not there, the pink sheets and all that, right? The PowerPoint presentations. Yes, originally we should have completed that process tomorrow. That's the 21st day. But now that so many things have occurred and we are not able to, it means that the 21 days allotted for the judges is what we are going to eat into. So if at the end of it, the judges also find that we've eaten too much into their time, so they will need more time to write their verdict, so be it. Yeah. Our law allows for such an extension.
Well, interesting perspectives there. Dr. Yini, I'm going to come back to you because there are a few things I needed to address for me that both Kojo Oppong-Nkrumah and lawyer Martin Kpebu had raised. But I want to take a quick break. When I return, I'll get into some of the substantive issues that have been raised for the John Mahama's legal team to respond to. Stay with me. So live here on PM Express, my guests are Kojo Oppong-Nkrumah. He speaks for the president's legal team. Also joining me is Dr. Dominic Ayine. He's a member of John Mahama's legal team and private legal practitioner Martin Kpebu. Dr. Ayine, before we went for that break, there are a number of issues that had come up for your attention, and particularly the issue surrounding a certain allegation that there is a strategy to in essence, score some points in the court of public opinion and draw the matter out.
I think...
So you fully benefit. Is that the case?
Evans, you know, on a lighter note, I have christened my colleague, Kojo Oppong-Nkrumah, the Minister for Misinformation. I think he's a former Minister for Misinformation now by my reckoning. But of course, you know, he made very...
In the words of that, I take strong exception to that.
Yes, but you know, he made a number of points that I would want to you know, respond to. First of all, what we are doing in court now is not by any stretch of the imagination, okay, theatrics. We are not playing to the gallery. We are not playing to the court of public opinion. Of course, we don't want to discount the court of public opinion, but we are actually trying to convince the third-party neutral arbiter of this election, that is the Supreme Court, okay, that the reliefs that we are seeking are well-founded, both in law and in fact.
But Dr. Ayine, I have a question. I have a question for you on that. When you say there's no theatrics, you're on question 3. You're asking the EC.
No, I would come.
Yeah,
yes.
I mean, but it goes to that. It goes to the point you made. You're asking the EC whether or not the 7th December was the first time we used regional collation center. This is an answer. You know a question you know the answer to for a fact. You know. So why are you asking it, if not for theatrical benefit?
No, you need to put that in context. And please go back to the prior questions. Unfortunately, I don't have, because I'm having to use my phone. I was going to use my phone as a source of information.
I can help you.
Yes.
There are two questions prior. The first question is, was there a practice in the previous presidential elections in the Fourth Republic of collated figures from constituencies being received in a strong room at the headquarters of the first respondent in the presence of agents of the candidates? And then question two, was that practice described in paragraph 1 herein followed in respect of the 7 December 2020 elections? And then 3 is where you ask the question about regional collation centers.
Correct. So as a matter of law, and I would say that, we as a legal team, and I'm sure of course, Mr. Chikata, knows that in CI 127, okay, the Regional Coalition Center, as part of the institutional architecture of our elections, was introduced. But the prior questions set the context within which, the third question relating to regional coalition centers was asked. Okay, we want a pattern of established practice to be described. What used to be, okay, the practice of the commission, the question whether those practices were whether the commission diverged from those practices, okay, as a matter of fact, not as a matter of law, okay, because the legal,
but it's not a matter in question.
As encapsulated, as a matter of, law, is encapsulated in, CI 127, all right? However, the factual compliance with that legal position is not something that is evident from CI 127. All right, and the interrogatories relate directly the factual, compliance. So, for instance, Evans, it could be the case that the law, established regional coalition centers for the first time. All right, but the question whether those regional coalition centers were actually set up and utilized, and that results were not coming from certain constituencies directly to the headquarters of the Electoral Commission. It's one that you cannot ascertain from the black letter of the law. Okay, so that question is deeper than meets the eye. It is not just a question of saying, yes, we established these, regional coalition centers for the first time in 2007. What was the prior practice, and what was the justification, for the regional coalition centers, and how were they utilized for purposes of the collation of results during the just ended presidential elections?
And the NCA question?
Something that is not.
And the NCA question?
Of course, that is also clearly relevant. Okay, and I'll tell you why it is relevant. Evans, if you go back to the answer of the first respondent, the Electoral Commission. The Electoral Commission was at pains, starting from paragraph 5 of his petition, all right, to describe the stages involved in the transmission of results. You can go back to their answer, and you will see that they were at pains to describe the stages: the primary stage, the secondary stage, the tertiary stage, and then what they called the quaternary stage. All right. Now, the question about the role of the NCA is to find out the extent to which the stages as described, okay, that chain was in any manner, broken by the role of a third party.
Do you have information that the third party was involved?
Of course, Evans, you are a journalist, and I'm sure you have seen a letter on social media that was written and signed by the chief executive officer of the I think it must have been the NCA. With respect, or the other way around. I'm sorry, my information again is on the phone. I was, reading that letter, trying to read that letter when I got here. But basically, some correspondence relating to the access to the EC system by the, or the NCA system for purposes of the transmission of results. As in the
EC inviting the NCA to help it transmit results?
I cannot state correct. I cannot remember correctly now, but there is that correspondence. I can make it available to Joy FM if you want. Okay, I saw it, on social media.
So bottom line,
but Evans,
could you just a second? Yes. Bottom line. Yes. You have some belief, based on that letter, that the NCA was indeed involved at some level in the transmission.
No, let me say this. I cannot say that was the basis of Mr. Chikate's arguments. Okay. All right, because I didn't discuss this issue with him. Okay. But Evans, I referred you to the answer of the first, the first respondent. Okay. In that answer, the first respondent was at pains to describe the stages. All we want to know is whether or not there was any break in that chain
that involved the third party
by the intervention of the National Communications Authority. Because as Mr. Chikata was at pains to explain in court, all right, by law, the NCA is in charge of electronic communication in this country. And no state institution, agency, or ministry, can engage in this type of communications without, the permission of the NCA. We just wanted to know whether or not the NCA was involved. Okay. And that is for us a genuine question. It's not one that can be lightly dismissed as Kojo has sought to do. That we are engaged in a fishing expedition. We are not.
Very quickly, because of time, I want to bring in Kojo and Martin Pil. But do you have the certified ruling now, and how does that affect your ability to comply with tomorrow's proceedings, which will set out the pre-trial case management sitting tomorrow?
Yes, we do have the certified true copy of the judgment of the court. It's a 4-page veritas judgment, I am very sure that as Mr. Chikata said, we would advise ourselves with respect to whether or not we want to invite the court to take a second look at it. We are not.
So are you contemplating what is it? An appeal? Well, I don't understand. Can you explain that?
Maybe an application for review.
Review. Okay. Kojo Ponkroma,
yes, maybe an application for review.
Mr. Ponkroma, yes, you had an intervention to make on this.
No, so just on the last point that he made, we predict that they will go for a review and even attempt a stay of the proceedings as part of their efforts to delay this. But let's see whether they do or not. On a lighter note, if you listen to Dr. Ayine, he appears to be, even though he says he hasn't spoken to Mr. Chachu Chikata, though he's their spokesperson, he appears to be articulating the potential reasons better than Mr. Chikata did in court, because you have an opportunity before the bench to give them reason to uphold your application or to shoot it down. If Dr. Ayine says that the real question they wanted to annex to the application was whether or not the original collation of results was done in accordance with CI 127. That's the real question they wanted to ask. That's what Dr. Ayine is telling us tonight. They didn't put that on the paper. On the paper, they said, was the practice described in paragraph 1 herein followed in respect of the 7 December 2020 elections? Question 3. Is the 7 December 2020 presidential election the first time regional collation centers have been interposed between? These are matters of fact that the court can even take judicial notice of, and they are not matters in question. Now, if again, as Dr. Ayine articulates tonight on your show, though he says he hasn't spoken to the team that he represents,
the real question it was on a specific issue that I said
of the NCA.
But you are their spokesperson, though. We are supposed to know they are thinking on these matters.
But let me make my submission.
If the real question that they wanted to put on the annexure was whether or not the relay of results from polling station to constituency to region to national, the chain of custody was broken by a third party in any way. They didn't put that on the paper. And within that opportunity that you have, when they've given you that breadth of opportunity to address the court, if what you have is what is on paper and the arguments that you have made, that's why the bench will come back and tell you that you have not demonstrated an issue of relevance, not issue of importance, but an issue that is of relevance to your pleadings that you have put before the court. Now, Evans, there's one last thing, because you don't have time, that I want to talk about. The role of preliminary legal objections in a hearing like this. Because we suspect that it will be one of the first things that, as part of case management, beyond the setting out of issues, one of the first things that need to be dealt with. Tonight, if I've heard the NDC communicators speak, some appear to be making the point that the court did not give them the liberties to advance their case. I dread a scenario where if our preliminary legal objection is upheld, they will say we have truncated the process. But
no,
preliminary
you are predicting
preliminary legal objections have a place in hearings. And we must begin to have a conversation to exercise our minds as to what is a preliminary legal objection. Yeah. Our argument is that what they have put before the court is not an election petition properly so-called, because they are not even questioning the validity of the election. Remember, in 2013, we questioned the validity of the election in a certain number of polling stations, that what took place in this number of polling stations, because there were breaches in the law in what took place in a number of polling stations. Yeah. These number of polling stations attaching our pink sheets are in question, and therefore they should be struck out.
Okay.
If you are not doing that, then the other thing you are doing is that you are telling us that the result as calculated at the polling station or the constituency or the region is different from what was finally put on the Form 13 and gazetted. Evans, my very last comment.
Very briefly.
If you take the pink sheets from the 38,000 polling stations and add them together, or if you take the pink sheets or the return forms from the 275 constituencies and add them together, or if you take the 16 regional summary sheets, you come to one answer. Nanado got more than 51%. It doesn't change no matter how you take it.
Now that you raise that point, Doctor, you have the final word. There's also another document, pardon me, affidavit of John Mahama in support, and then you list some of the details in there, including the calculation.
Yeah, a number of documents, originals that we want to inspect.
Yeah, so this is the one you filed today.
Yes, that was filed this morning and served on the respondents.
Okay, so you want the court to also entertain that tomorrow?
No, not necessarily. That is not by way of an application.
Okay.
It's a request to inspect the documents.
Okay, so they can either grant it or refuse it?
Yes.
Okay, but there's another one I see on where you detail, John Mahama details, this was filed on the 18th, right? And you are asking the EC to admit the errors, but also talking about the declaration that she made on the 9th. What's that about?
Okay, let me go back.
Forgive me. I just have a minute to wrap up. I just have a minute. So I wonder how that, what role this is playing on that too.
Okay, the role that it plays, is at the heart of the validity of the declaration that was made on the 9th. That is the role that it plays. But I want to, let Kojo understand that. Okay, election petitions, if you read the Constitution very well, do not necessarily have to attack the validity, of an election. They are also about the mathematics, all right, of an election. So you have Article 63, clearly, 63.3, spelling out quite clearly that a person must obtain, more than 50% of the vote. And
that was my last point.
And we are saying that your 51% that you are talking about, cannot be, proven, given the evidence that we have.
Okay.
And our evidence is that you did not obtain 51%. You did not obtain up to 50% of the votes.
Okay, we'll see.
More than 50%.
Thank you, gentlemen. This will play out in court tomorrow. We'll see how the case is managed once that case is called. I'm grateful, Kojo Nkrumah, Doctor. We lost Mr. Martin Kpebu on the line. But I'm pretty sure he's been gracious enough. He will join us through the process as we help you break this down so you can understand what is happening at the Supreme Court. My name is Evans. Enjoy the rest of your evening.